Dear colleagues, good evening. My name is Victoria Manko, and I'm the General Director of the International Comparative Law Research Center. I'm delighted to welcome everyone at our center and at the workshop dedicated Investor-State Dispute Settlement Reform. I believe that everyone looks forward to productive discussion on this complicated topic. And I'm very glad that today we have experts from different parts of the world with rich experience and diverse backgrounds. The topic we are going to discuss is indeed not easy one, let's say even controversial. And the idea of creation of Multilateral Investment Court has received both support and criticism among stakeholders. Last summer, the Center has received the status of observer in UNCITRAL Working Group III, and we do our best to contribute to the discussion. And this event is the further step to enrich ongoing discussion in Working Group 3. From our point of view, it's very important to give the floor to representatives of legal community to share their thoughts and ideas about creation of multilateral investment court, because it will be affected by outcomes of negotiation. Here at the center, we are happy to serve as a platform for discussion, for exchanging ideas and thoughts by experts. And on behalf of the center, I would like to express our appreciation to UNCITRAL Secretariat for supporting this event, all speakers and participants for coming, and all guests today here, and those watching us online. Now I give the floor to Mr. Sergey Ososkin, who kindly agreed to moderate this session, and wish all of us good discussion. Thank you very much.
Thank you, Victoria, and thank you very much to all the members of the audience for coming or for joining us online to discuss this exciting topic. Before we start this discussion, and before I outline how we are going to approach this very interesting and controversial issue of the investment court, I have several administrative remarks that I should make. One is that if you are joining this seminar via an online broadcast, you can ask questions. I understand there is a chat window in the broadcast, and you can type your questions there, and they would be passed on to me, and I would read them, and hopefully we would be able to address them to your satisfaction. Also, to those of you who are present in this room, we encourage you to ask questions and participate in discussion, but if you, for some reason, would like to ask the question in writing, I understand that over there are separate sheets for questions that you can write down and pass again to me, so that those questions are announced if necessary in this way. In terms of how this discussion is going to be structured, as you have seen from the program, we would start from a panel discussion on this subject, and the second part of the seminar would be an open discussion involving all the members of the audience. With respect to the first part, again, there are a number of elements. First, we would have an opportunity to enjoy the amenities of the 21st century and listen to the Secretary General of UNCITRAL, Anna Juven-Brett, who kindly recorded a special video addressed to the members of the seminar describing the discussion at the UNCITRAL Working Group III on the reform of investment arbitration. We would then move to the presentations from the members of the panel, and I must say that I am privileged to moderate a truly outstanding panel that has the diversity and experience that I think are appropriate to discuss the subject, both in terms of geographical representation, representation of investors and states, investment state dispute settlement, and also importantly, representation of neutral institution involved in administration of investor state dispute settlement. So before we go to the presentation, in the final note, let me introduce the members of the panel, who I believe don't need any long introductions, but still. Sitting to my immediate left, and from your perspective to my immediate right, is Diego Gozes, who is partner at GST Law in Miami, and who has significant experience representing parties in investor-state arbitration. Next to Diego is Evgenia Garacheva, who is a senior counsel at the Permanent Court of Arbitration. And again, I understand this very, very significant experience involving administration of investor-state arbitrations. To Evgenia's left is Baju Vasani, who is partner at Ivanian Partners. And we understand from reading Baju's biography that had very significant experience representing investors, but now, as some of you may probably know, would have a significant task of representing a certain state in investor-state arbitrations. And last but not least is Professor Mikhail Risvas from IE Law School in Madrid. Professor Risvas is not only an academic, but also had previous experience advising and representing investors and states in investor-state arbitration as counsel and advisor. So with that, I am pleased to give the floor to Madame Joubin-Brett.
Hello, good morning from Vienna. My name is Anna Joubin-Brett. I'm the Secretary of UNCITRAL, and I'm very glad for this opportunity to present, albeit remotely, UNCITRAL's contribution to this workshop organized by the International Comparative Law Research Center. So thank you very much for having me, and I'm looking forward for those who will be joining us next week in Vienna to see you there and then. I'd like to give you a short introduction on the work that has been already undertaken and that is planned for the working group of UNCITRAL on investor-state dispute settlement reform. This working group, this work has been entrusted by the mandate received from the Commission to Working Group III. It was received on the 21st of July 2017, where the Commission entrusted Working Group III with a broad mandate to work on the possible reform of investor-state dispute settlement. The working group has undertaken its work following the usual working methods of UNCITRAL with some specificities. One of them was clearly explained in the mandate that this work has to be government-led, that it requires high-level inputs, that it will, as all the work in UNCITRAL, be consensus-based, that it be fully transparent, and that it also builds and involves the expertise from all stakeholders. And this is what we in the Secretariat have tried to achieve during the first 2 years of the work of Working Group III. We have also put special emphasis on increasing the participation, particularly of developing and least developed countries, into the work of this working group in order to ensure that it is inclusive and that it involves all the countries, or as far as possible, all the countries that have experience in investor-to-state dispute settlement or that have concluded investment agreements or investment contracts that include investor-to-state dispute settlement provisions. As a graph that we have issued in 2019 shows, there has been a steep increase in the participation of developing countries, and at the last 2 sessions we had over 100 states present in the room to deliberate, and we also were assisted by 70 plus NGOs and international organizations with their relevant expertise. In addition to the working group sessions, we also held and organized with host countries a number of intersessional meetings. The first one took place in Incheon in Korea in September of 2018. It was followed by an intersessional regional session for Latin America and the Caribbean that took place in Santo Domingo in March of 2019. The last regional intersessional meeting took place in Conakry in Guinea in September of 2019 to involve all of African countries. We are now changing the approach to the intersessionals that will focus more on identified topics for reform rather than on a regional focus. But again, this is completely in the hands of the member states who will decide what they want to do. We have completed, as I mentioned, already 2 phases in our mandate. The first phase was to identify and consider the concerns regarding ISDS, the concerns that are widely heard or that are sometimes also shared regarding investor-state dispute settlement. And I should say, not surprisingly, there was a very broad consensus around these concerns. Similarly, there was also broad consensus as to whether reform was desirable in light of any identified concerns. This was step 2 of the mandate. And here again, there was a very strong support in the working group regarding the areas where reform is needed and where reform should be started. We've reached now the third and last step of the mandate, which is to identify, and if the working group were to conclude that reform was desirable, identify and develop any relevant solutions to be recommended to the Commission. We had packaged, in order to make it easier to navigate, the concerns identified by the working group into 3 broad sets of concerns with a few satellite issues, and I will very briefly summarize them for you. A first concern relates to cost and duration of the ISDS proceedings. Not only cost and duration, but also the fact that so far the mainstream solution is that each of the parties involved in such a dispute bears its own costs, and the question arose as to possible cost allocation between the parties. And similarly, the issue of security for costs that we will be talking about a bit later. The second set of concerns, or basket if you wish, relates to consistency, coherence, predictability, and ultimately correctness of the awards and of the decisions rendered by the ISDS tribunals. And we identified a number of unjustifiable, inconsistent interpretations of investment treaty provisions, taking into account, of course, that some of these interpretations are not are justifiably inconsistent because the basic treaty wording may differ. There is also a lack of a framework for multiple proceedings, which results in a state, for instance, relating to one measure or to a particular relationship with an investor to have to fight not one, but 2 or 3 or 4 parallel proceedings, either because they are brought by different shareholders, or because they are based on contract and treaty and, for example, an investment law. Then another issue which also relates to consistency, coherence, and correctness is the absence, the lack or the limitation of a mechanism to address such inconsistency and incorrectness in decisions, meaning that there is no mechanism to appeal or to adjust an award that would not be correct or that would be inconsistent. The third basket of concerns relates to arbitrators and decision makers, to the lack or apparent lack of independence and impartiality, to the adequacy, the effectiveness, and the transparency of the disclosure and challenge mechanisms, to the mechanisms for constituting ISDS tribunals, and to a lack of appropriate diversity that was again agreed upon across the board. Another topic which is a little bit standalone is the issue of third-party funding that was also identified by the working group as an issue of concern, particularly as far as its definition, its use, and its lack of regulation is concerned. So for all of these sets or baskets of issues, the working group considered that reform was desirable, and we started developing reform options. The way forward that the working group agreed upon was, in as far as the development of these reform options is concerned, was to develop potential reform solutions simultaneously. The idea, after a lot of back and forth, was to ensure that all the efforts of the working group would not focus on one solution, but that it would equally be able to move along other solutions so that it would not take too much time to achieve a result for these solutions. It was repeated numerous times that, as the mandate says, these reform options should focus on procedural aspects of ISDS rather than on substantive aspects. But here again, you will agree with me that sometimes the dividing line between the two can be fine, and so we will have to really see how, as we go forward, how this issue is addressed. We also called upon states to make submissions as to what are their preferred avenues for reform, what are the options they would like to either put on the table or support. And we received 19 submissions by 48 countries with concrete reform proposals. The Secretariat worked and prepared the working papers that were submitted to the working group for its deliberations. And what we did for the forthcoming session and for the last one as well was to weave into the documents prepared by the Secretariat the proposals and the submissions received from states. And the Secretariat summarized these different options in a tabular form in a working document, Working Paper 166, that presents reform options that have been discussed. As far as the implementation of this reform is concerned, we received several submissions by states regarding the form that this reform effort could take. And here what I would like to highlight is the important issue of the existing treaties and the need to cater for these existing treaties with reform, not only looking forward, but also looking at this huge stock of old, mostly first or second generation treaties that require substantial reform. So having this in mind, we received some submissions relating to the possibility to implement various reform options simultaneously through an opt-in convention. It would be a multilateral instrument that could be modeled after the Mauritius Convention on Transparency or the OECD BEPS treaty, and could ensure that the application of this reform would apply also to existing treaties, which, as I mentioned, is one of the main concerns for a number of countries. So this has brought us to bring together some of the elements of the reform as we have received them so far. And what you will see is the what we call as a joke amongst ourselves, the little house in the prairie, which is meant most importantly to show that there is coherence and consistency in spite of the very different proposals that we have received and the different areas on which these reform options focus. Basically, to show them in the form of a house allows to see that it could cater for an existing system alongside the first instance investment court proposal of the European Union, alongside the favored methodology of recourse to domestic courts that a number of countries have now put in their latest version of investment treaties, and also state-to-state procedures. All of these could constitute entry doors for investors who could enter the ISDS system either through an arbitration or through a first instance court proceeding, or bring their case for espousal to their state of origin. But where we continue to remain coherent is when we reach a second level, which would allow to have an overarching appellate mechanism that could apply either as a second instance investment court, but also as a standalone appellate review or appellate mechanism, which would of course have to cater for the existing ICSID convention, which provides, as you know, that an ICSID award is final and binding, is not susceptible of appeal, and could also, and that could be a maybe smaller window, but could also allow to deal with the very small possibility to challenge a court decision taken in some countries that prefer domestic remedies in the case of a denial of justice by these courts, by these domestic courts. And in order to ensure that there is broad coherence and that states remain as they wish, the masters of their treaties, there is state control through treaty interpretation tools, through refining and clarifying substantive standards that could be done by other institutions, but making sure that the whole remains coherent and does not result in a more fractioned system than what we have already. And as you can see, there are two lateral wings to this little house in the prairie. One that consists of strengthening and actually offering ADR on a more sustainable manner, either ADR in general or focus on mediation, which will be one of the forthcoming working papers, or the use of an ombudsman to ensure that there is early attendance to the claims. And another area where support to the parties in dispute is needed is through dispute prevention, through investment facilitation, but also through the establishment of an advisory center akin to the one established in the WTO to ensure that the WTO dispute settlement understanding offers a level playing field. You will see that we continue with our little house in the prairie with this floor plan, which could show, which tries to show at the two levels of the house what could be the different rooms inside the house and how this could then feature inside a multilateral convention. So there could be a code of conduct that could be applicable across the board. The issue of counterclaims, of reflective loss, of security for costs, of third-party funding that I mentioned, also about multiple proceedings, have been identified as requiring reform. and we could think about a reform of these for these different elements through such a multilateral opt-in convention. But in order to help you prepare for the forthcoming session, which is starting next week, I just wanted to show the different working papers that you have at your disposal. So we have already discussed in October the background information on a code of conduct, the advisory center, as well as third-party funding. These three elements have been identified for reform and will be further developed by the Secretariat. The next topics will be an appellate and multilateral court mechanism and selection and appointment of ISDS tribunal members. This will be discussed in January next week in Vienna. What I'd like to share with you also is some flags to identify the different submissions we received from governments, and to highlight that we have recently received 2 submissions by the government of Russia that will feature as 2 separate working papers that are currently being submitted to a translation into the 6 languages. So what is on the agenda? What is on the work plan? As I mentioned, at the 38th session in Vienna on the 14th to 18th of October, we discussed the Multilateral Advisory Center and related capacity building activities, a code of conduct for arbitrators and adjudicators, third-party funding, and we started discussing the proposal for the development of a multilateral instrument on ISDS reform that we are now turning into a working paper. The next session will be about standalone review or appellate mechanism, standing multilateral investment court, and selection and appointment of adjudicators and arbitrators. The session in New York, to which I would like also to invite you wholeheartedly, will discuss dispute prevention and mitigation, treaty interpretation by state parties, security for costs, means to address frivolous claims, and early dismissal of such frivolous claims, multiple proceedings including counterclaims, effective loss and shareholder claims based on joint work with the OECD, and consideration of future work plan, including whether to request additional working time. So I hope that with this I've given you a fairly comprehensive picture of what we have done so far and what we have in the pipeline here in Vienna and for the next session in New York. I wish you very fruitful deliberations. I look forward very much to seeing you in Vienna very soon. And as you can see, in Vienna it's already spring, so I hope that the snow will soon be melting in Moscow as well. Bye-bye.
The technology is not yet ideal in all respects. But anyways, so you heard that there are a lot of concerns with respect to the investor-state dispute settlement system, and there are a lot of proposals. And it seems from looking at some of the criticism of the investment-state dispute settlement that it's a long and costly process that's run by biased adjudicators who nevertheless somehow manage to be inconsistent in their decisions. And so one has to wonder why parties still continue using it. But as you have heard, there are a number of ways of addressing this issue. It is a reform of investment arbitration in multiple ways. It is more significant role given to mediation, conciliation, or to national courts. And one proposal that we would focus on today is a proposal to create a permanent investment court, which would not be biased, which would be inexpensive and very, very fast, and which would achieve complete consistency. And well, the task, or I think the topic of our discussion today is whether this is actually achievable. And if we look at the investment court as an alternative, as a solution to all of these issues, to what extent it would fit the task and how it would operate in practice. And to this end, we have discussed 4 topics that each of the speakers will address one of the 4 topics that we thought are kind of at the core of this discussion of how a possible investment court may operate. So we will start with Baju, who would discuss the jurisdiction of the court, whether it should be a court, whether it's a appellate mechanism, what kind of decision. Then Diego, on how do you avoid unbiased adjudicators? How do you achieve some of the other criticisms, such as lack of diversity? Then Kenya would talk on how the court may be organized, what would be the role of the judges, permanent judges, semi-permanent judges, areas. How would this marvelous institution be financed in less expensive? And finally, last but not least, a very practical frequently arises some question of enforcement, because the investor state arbitration system benefits the existing framework of the Court Convention, very much aware of. So Mikhail talked on the enforcement decisions of the investment court, how these can current position. So this is how we are going to address it, and that you are welcome to ask questions or express your position on the issue, or any of these issues. And with this,
Sergey, thank you. Good evening, everyone. So we're told by the Secretary General of UNCITRAL that we have a problem. And we're at a precipice where states have proposed various solutions. And the question is, are these solutions fit for purpose? Which solution should we choose? Should we choose the mick, which are the Multilateral Investment Court? Should we choose an appellate mechanism, or neither of the two? The way I want to approach this first, and suggest that we all approach the question of which solution, is by looking at the question, and bear with me on this, but the question of salad and obesity. And the question is, well, why are we talking about salad and obesity? And I will explain. In the Western world, and you may have this here, we have an obesity epidemic. And unfortunately, I am a net contributor to that epidemic myself. Now, schools wanted to do something. They wanted to have kids eat healthier in school. And they came up with various solutions. How do we get them to eat salad? The first proposal was what I would call encouragement. Let's just put some posters up. It's good to be healthy. Let's have some classes. Everyone says, yeah, it's great to be healthy. And let's see what happens. So they did that. And what happened? There was a short spike, you know. They took salad for the first couple of days, but then they went back to their burgers and their French fries. Then there was the second solution, what I call the sledgehammer. And that was, let's just throw out the junk food. Problem solved, right? No burgers, no fries, you just have salad, so that's the solution. But what happened? It didn't work. Why? The kids didn't eat the salad. They complained. It lost popularity. People would sneak junk food into the school. And eventually, when they scrapped it, the junk food actually went up from what it had previously been. So this sledgehammer approach didn't work. So what did work, and this was fascinating to me, was all they did was, you know, so when you go for a buffet at a school or hospital or where you work potentially, you've got a line of foods and then you pay. All they did was move the healthy food to the front and the unhealthy food to the back. That's it. Simple solution. And healthy eating spiked and it remained consistent. Now, why do I talk about this salad and obesity? It's because a nudge, a simple tweak, can create institutional systemic change. One doesn't need the sledgehammer to throw out the junk food in order to create lasting and permanent systemic change. So let's hold that paradigm that I've just described and talk about how we can look at it in terms of ISDS reform. We heard some of the issues, and as someone who has practiced both as counsel and arbitrator in the system, they have some merit. It's not the worst system in the world, but by all means, it has some issues. Legitimacy, I agree, is a problem, and I know Diego will talk more about that, but you do have the point that only a handful of arbitrators are deciding the vast majority of decisions on very big regulatory issues of environment, tax, health. And those arbitrators come from a very narrow part of the world. They're mostly men, and they're mostly above the age of 60. And so the question is, well, should these three people be deciding on such important topics? You've also got, I agree, the question of uncertainty and consistency. What is the meaning of, for example, MFN, most favored nation clause? Can you bring in substantive protections? Can you bring in procedural protections? What is the meaning of fair and equitable treatment? You know, do you need an actual promise from a state, or is it sufficient that the regulation itself enticed you or induced you to invest and then drastically changed? Umbrella clause is another one. Do you need to have a sovereign breach? Do you need to have privity between the two parties? We also have an issue of bad decisions, right? You do. I mean, I always say that any case I lost was a bad decision. So you do have bad decisions, not many, but you don't have really a mechanism to weed out what I would call real errors of law on the merits or real errors of fact on the merits. ICSID, as you know, has an annulment mechanism, but that is very procedural and it's very limited, and state courts themselves are divergent on the manner in which they can approach cases. So we don't have a way of properly appealing as you do in domestic courts. And of course, time and cost is something I remember when I first started my practice, we would be doing ICSID cases within 2 years. There would never be jurisdictional objections. There would absolutely never be annulment. And now you have to have your manifest error, you have to have your corruption allegation, you have to have your jurisdictional objection, and all the way across the process, every single procedural issue is fought tooth and nail. So we know there has to be change to the system, and I think there is consensus among states that that needs to take place. The question is, what's the answer? What's the solution? So first of all, we know that the encouragement approach, the posters that we put around the schools, that's not working, right? We'll all sit here in this conference, there'll be conferences around the world where everyone will agree that there's an issue and we need to solve the issue, but nothing will happen. Everyone will still go back to eating their burgers and their French fries. So we actually need to have some sort of reform. So the question then is, well, do we want the sledgehammer? Do we want to throw out the junk food, which for me is the mick? Now, the proponent of the mick is, of course, primarily European Union or European Commission. You have a standing court. You removed ad hoc tribunals altogether. And my colleagues are going to discuss the aspects of the mick in more detail. But let me give you some thoughts on the mick as a process. I think, first of all, now you would say, I'd say this as a British national divorcing the European Union, that I'm going to be anti-EU. Yes, I think the EU has an agenda. And the agenda it has is that it hates ISDS, and it hates ISDS because ISDS is a threat to the dominance of EU law within the EU, and they don't want that, and we know that from the Achmea decision. However, I would also say that the mick doesn't necessarily fix the issues. And I'll just pick a couple very quickly. Legitimacy will be, it depends on where these people come from, who sit on the standing court. Will they be judges who don't know anything about PIL? Would they be arbitrators who we have now? Well, you're both going to have issues depending on where you go. You're also going to remove, and I think this is critical, the best part of international arbitration, which is the flexibility to pick your own arbitrator. Right, that's gone. It's not arbitration then, as far as I'm concerned. It's just another court process. You also don't address the concept of why are we protecting foreign investment at all? And that's something that didn't come up in the Secretary General's remarks, which is the debates I've had with NGOs around the world has been on the concept of why protect foreign investment at all? Why do they get a court? Why do they get a special law? Why do they get a special regime? Why don't we protect domestic investment? And the question is, what is foreign, right? It takes like that to create a foreign company, like that to transfer money from here to Cyprus, so and then regurgitate it back. So is that really so special that we have to protect it? Arguably not, and the standing court doesn't address that question. Predictability and consistency, again, the question is, well, you have so many bilateral investment treaties, unless you have one treaty with absolute perfect standards, you're still always going to get some sort of fragmentation by the court. And the question is also, we will get consistency over time. In other words, the court will tell us right now, this is the answer, and that's that. And people say, that's good. You get absolute consistency immediately. But I say, well, we'll get consistency over time. Yes, we do have differing opinions right now. Over time, that will change. And why is that? It's because this system is a teenager. In its life, it's a teenager. It's an unruly teenager. It's not behaving itself. But over time, that consistency, because the school of thought, one school of thought will overcome the other and will have consistency in a better way, not just by diktat of the court, but by various people deciding ultimately that one school of thought was better than the other. You're also, of course, going to get fragmentation in the interim because we're going to have a mick. We will have a mick for some BITs and not for others. And so we're going to get a whole host of different jurisdictional decisions. So then the question is, okay, if we're against this big sledgehammer, it doesn't fix the system, and I've just picked a few issues. What about the smaller sledgehammer, the smaller one, which is the appeal mechanism? I have to say this one has more appeal, if you'll excuse the pun, than the standing court. Here you'll keep the ad hoc system, but then move the ability to appeal up to this court. But again, the questions remain, who's going to be on that court? You won't get rid of the system of these three judges, or three arbitrators deciding big issues. And again, because of the nature of BITs, you won't, and the differences and nuances of wording in BITs, you're not going to get absolute consistency. So in the paradigm of what do we do to fix this issue, I support the position of the Russian Federation. That may be not a surprise considering my counseling position, but the Federation has taken the position that what we need are nudges, right? What we need are a series of moving the salad to the beginning of the line, which will result in systemic and institutional changes. You can have transparency, so that it's not secret tribunals, by signing the Mauritius Convention. You can have mediation by signing the Singapore Convention. We can address who should be an arbitrator, how much disclosure they should make, what kind of double hatting procedures. Let's look at their workloads. Let's look at how much use of secretaries they have. We can have interpretation of bilateral investment treaties by state. So each state can say, here's what this BIT means. Let's all publish the travaux préparatoires of every bilateral investment treaty. Why don't we have mandatory intervention of amicus of a state, of the home state in each BIT to say this is our understanding and interpretation of the BIT. We can have a commission that can assist states to ensure that they are able to react in ISDS appropriately. As counsel, I would welcome procedural changes, simple ones. Let's have page limits. Please, let's have page limits. Let's have arbitrators that give strict deadlines. Let's have domestic exhaustion. So these are just a few of the nudges that one can have without the big sledgehammer of throwing the junk food out. Because I would suggest that this teenager that we have is worth keeping, and we have to allow him or her to grow up. Thank you.
Thank you very much for this excellent presentation. Also, I think a lot of useful comparisons. So before I pass the floor to Diego, I'm going to just plagiarize a bit on what Pedro said, because this obesity problem is something that's near and dear to me as well, unfortunately. But one of the issues that came up to my mind was then you have to eat healthy, you have to drink healthy. So instead of soda, it's much better to drink water. And so what a number of water producers started to do is to market water that has a lot of sugar in it. And so if you just change from Coke to certain types of water, nothing actually changes. And the same, I guess, the question I'm going to ask Diego is, by switching from investment arbitration to investment court, in terms of diversity and lack of bias of the adjudicators, are we replacing Coke with good water, or are we possibly buying something which is very close in composition?
Thank you, Sergey, for the question. I will start with a few procedural remarks, and of course words of appreciation. Thank you to the organizers and Victoria for having me here. It's always a great pleasure to have an excuse to come to Moscow. Thank you, Sergey, for a very successful moderation of the immoderable discussion we'll probably have. And thank you again. Yeah, I'm left-handed, so I'm basically using her table to entertain the discussion. The warning I have to start with is not to fall into the temptation that the Badger has fallen into. I will not say anything that represents the views of my client's past, present, and most importantly, my client's future. I have had the privilege of the last 15, 20 years to be involved in the world of investor-state dispute settlement in different capacities, including representing Argentina, Venezuela, and Bolivia, and Ecuador in investment-state disputes, but also representing sovereigns in the workings of Working Group III at UNCITRAL. I've been privileged to have been able to attend every single one of the sessions of Working Group III, and I'm actually on my way to Vienna over the weekend to attend this next session. So I've seen most of the issues that have been raised as concerns by civil society, by the community of states. One or more of the 70-plus investment cases I had the privilege to participate in have seen these things happen in the flesh. This unruly teenager of ISDS has, on some occasions, taken to stealing the car keys, which makes things a bit complicated, not only in terms of whether we want to keep the teenager, but also whether legal action is actually needed to be adopted. A very senior professor of procedural law in Argentina, where I studied and lived for the first 37 years of my life, told me once that if forced to go to the Supreme Court, one should try and reach any form of agreement possible with the opposing side to just toss a coin. Because in that case, they each knew they had 50% chances of forecasting what would happen. Now, the Supreme Court of Argentina, that has had, of course, a number of interesting compositions over the last 10 decades, has not been especially foreseeable in their results by reason of being a permanent body. So going partially perhaps to Sergei's question, the permanence of the adjudicators and the fact that they usually sit in the same bench over 5 to 6 days a week with some luck for a number of years or decades does not in itself change the problems that are being discussed in terms of the coherence of the decisions, in terms of the foreseeability of the results that are ultimately obtained. And this is something that is as troublesome to claimant parties as it is to respondent parties. One of the main issues with inconsistent decisions, and this includes inconsistent decisions by tribunals that include the same arbitrators, or inconsistent decisions that includes claims by the same claimant, or another shareholder of the same entity, or another member of the same family, and there's still a wealth, it's probably an oxymoron, because a wealth of contradicting decisions there. But just to narrow down the issue to situations where probably the identity of the arbitrators or an improvement in the system to appoint and control and ultimately challenge adjudicators could have possibly changed a little bit. This is what I'm going to discuss, what Anna Joan Brett identified as the unjustified inconsistent decisions. There is, of course, and Beige makes a very valid point that no matter how deep and successful the work of Working Group 3 is, no matter how well accepted a multilateral instrument dealing with reform in ISDS becomes, there will remain areas where decisions will come out which will be naturally inconsistent. And that has to do with the fact that there's about 3,000 plus different BATs with somewhat discrete language aimed at protecting specific areas of state conduct vis-a-vis foreign investors. But there's things like the ICSID Convention, 180 plus member states, and one set of rules, and one appointing authority, let's call it that, and administrating agency, but still on the interpretation of the ICSID Convention itself, there is a wide variety of decisions on the exact same point. For instance, there is a decision from a short few years ago where an ICSID tribunal found that the denunciation of the ICSID Convention by a party when one read Articles 71 and 72 did not constitute a bar to the submission of a case within a certain period that would still be subject to the jurisdiction of an ICSID tribunal. Months later, same party, the same analysis of the same Articles 71 and 72 of the ICSID Convention, another tribunal issued an award that basically finds the exact opposite, that because of the date, the same date of the same denunciation made by the same instrument with the same number of characters and the same period in Articles 71 and 72, a claim that was filed within the same time period would in fact be barred from being entertained by an ICSID tribunal. Now, of course, the losing party on both those cases filed for annulment. As of now, only one of the decisions on annulment has come out, and it's an annulment committee has found that, in fact, the decision that barred jurisdiction of an ICSID claim after the ICSID Convention had been denounced was not to be annulled, and so that is the status of law. But as a claimant, as a lawyer for a claimant, or a firm that represents claimants more than respondents, it's very hard to sit on your meeting room table and look a client or prospective client in the eye and say, well, this is the status of the law and this is what's going to happen, and you should or should not invest $2, $3, $5, $7 million in getting a claim going on until you, after a number of years, get a final result. For exactly the same reasons, it's very hard to represent a respondent state and tell them, well, this measure that you're thinking of adopting, you would be safe or you would not be safe in adopting because it does or does not breach in national law, in national investment law for this or that reason, because on many points which deal with the exact same legal instrument or the exact same legal rule coming from international customary rule, coming from multilateral instruments, including the ICSID Convention itself, but also in the interpretation of the exact same measure under the exact same treaties, there is a wide variety of cases which makes the cost of engaging in dispute settlement through ISDS something that is unnecessarily high and borders on unreasonable. Now, the particular issue of appointment of adjudicators and the methods to appoint adjudicators and the methods to assign cases to adjudicators, and we'll get to that in a minute. It's one of those areas where every proposition that is made, and one has to assume all are made with utmost good faith and with no other purpose than to improve the system, fails at one point or other to actually address all of the issues that have been very validly identified in the discussions of Working Group III. The only actual forecast one can make of this is that the plan that Anna Jovan-Brett was mentioning of when Working Group III would address each of the several issues that are the layout of this little house on the prairie and the many different layouts for the furniture that should go in each room, it's somewhat unlikely that will satisfactorily be addressed in the very optimistic time frame that is in place. Everyone is doing the utmost best to actually meet those deadlines, but one of the most encouraging processes that UNCITRAL has adopted in regards to this, having attended every session of Working Group III from the inception of the work throughout the last session in October last, is the very dedicated rhythm that UNCITRAL has set to the discussion to guarantee that the largest possible number of states and actors from civil society, from academia, from practitioners, guilds, to call it something, take the opportunity to make any and every possible comments, so that in the end there is a very deep feeling of ownership by the international community, by the parties, by their lawyers, by the constituencies of the many states that are involved in the ISDS system over the final results. A very good text that is not felt as having been adopted, taking into account the concerns of every individual stakeholder, is not would be a fast document to arrive at, but would not be a satisfactory solution, in that one can already foresee the ratification would probably not be very successful. This is one of the concerns that have been expressed with respect to the Mauritius Convention on Transparency. Some say the convention was drafted so solidly that many states did not feel that they had a very active say in the drafting, and so the period it has taken from the first ratifications to the actually entry into force of the convention reveals that there was not a deep sense of ownership by the international community of that instrument. This is something that UNCITRAL is actively working towards avoiding by doing everything, including the intersessional meetings that Angela Ambret was mentioning, to involve every possible voice. And this variety of voices have suggested a number of different alternatives to deal with the issue of the appointment of adjudicators. The main categorization of alternatives is based on whether a system for standing bodies or ad hoc bodies, permanent, semi-permanent, or custom-made groups of adjudicators should best be used to address the concerns regarding the constitution of tribunals. And the gamut of alternatives starts with, of course, permanent organizations of the of tribunals of the type that one is used to seeing, for instance, in the workings of the International Court of Justice, or semi-permanent, and the International Court of Justice is again, at the risk of contradicting myself, a good example of that, in that the constitution of the court itself may change somewhat to include representatives or members appointed by the disputing parties to, in a way, put a bit of a limiting effect to the permanent nature of the body, so as to allow for a certain additional flexibility of arguments and expected results in the tribunals. There is open and closed systems. There are systems where the disputing parties have no say in determining who will hear a decision, who will hear a dispute, where the arbitrators or the adjudicators are chosen by a third party, an appointing authority, without any input from the parties. And there is again a gamut of alternatives that ends on the other side of that rainbow, with systems where it is the parties themselves who take every single decision on who the typically 3 members of the adjudicating body will be, and the range of possibilities goes from the most party flexible approach, that it is the parties themselves who appoint even the neutral third party, sometimes called an umpire, who will preside over the proceedings, to systems where the decisions on the identity of the adjudicators are more and more detached from the parties, starting from the third member being appointed not by the parties but by the arbitrators that have been appointed by the parties, to a system where 2 members are appointed by the parties, but the third one is appointed by an appointing authority or administering body. And so that's the range of possibilities as seen from who is it that appoints the parties. The one nuance that is interesting, and some of the papers that have been submitted for this discussion mention the issue, the note from the Secretariat that has weaved everything into a single fabric and has been submitted to the participants for the session this next week, makes an interesting distinction between the appointments of the adjudicators and the assignments of the specific case to those adjudicators, which is a nuance that may, if you start analyzing the issue from a textbook, may not come at first blush as something that you would realize is itself an issue. But the perfect example of this is, for instance, the way that ICSID operates, in that the list of arbitrators, especially as it comes, for instance, as it comes to annulment committees, where ICSID is limited to appoint arbitrators to annulment committees from the list of arbitrators of ICSID is based on the list that includes the appointees that the member states have made to the list of arbitrators of ICSID. Each state has the ability to appoint 4 members to the list of arbitrators. There is an additional possibility for ICSID to appoint an additional number of arbitrators that have not been elected by the member states, but that list exists before any decision on who gets to hear a particular case is ever made. And so it's one thing to have chosen arbitrators for purposes of creating this very aggregative list of arbitrators, and a very different thing to actually have the ability to see how a particular committee is created, even if the names are restricted to those that made it in the list. And this is something that, in the case of ICSID arbitration, is sometimes resolved within a few days, but sometimes I'm currently awaiting, for instance, the composition of an annulment committee in a case for which a request for annulment was filed early in November. We're halfway through January, and still ICSID has not submitted names for that committee. So the distinction between the identity of the arbitrators and the actual assignment of a given case to a particular 3-member group of that panel is itself an interesting additional nuance. The concern that has been probably the subject of the most debates in the workers of Working Group 3 is who should be represented and how to guarantee a sufficient representation of sufficient diversity in the tribunals that will end up deciding on ISDS disputes. And the issue, of course, the debate came at the point of coming to consensus on what forms of diversity should be taken into account and how to take that diversity into account. There's been suggestions that gender diversity has to be sufficiently taken into account. There is, over the last 10-15 years, there has been a very powerful drive towards guaranteeing a more equal representation of men and women in arbitration appointments. By way of anecdote, and Beju was mentioning the very limited number of people that has heard the most number of cases. The first 2 in the ranking are women, and as this was being discussed in the session, I think that was a session in New York, and the issue was being raised that, well, but there's this issue that about 30% of the disputes have been decided by no more than 15 people, and actually one of them has heard over 55 cases, and that one person walked into the room and sat quietly, one of the countries starting with letter S. So there's the issue of gender representation, which one has to add perhaps some food for thought, the issue of how many genders there exist and what limits actually there should be to how to design a system that matches the international community's expectations on the identification of gender, and then for the representation of gender is something that cannot be easily let aside without some thinking. The issue of the representation of different forms of economic activity. This is the language basically in Article 14 of the ICSID Convention, of course. And this is one of the economically driven considerations to take into account. The other is, of course, the level of development of the several participants in the appointment process, and there is the tension between, especially in the case of investment arbitration, where conceptually the treaties originally were negotiated between capital exporting countries and capital importing countries on the assumption that the capital exporting countries were more developed than the capital importing countries. I do not know, actually know the opposite to be true, that this currently still reflects sufficiently the quid pro quo at play in investment treaty negotiation and also in investment disputes. There are, for the first time over the last 5-6 years, we've seen cases brought by nationals of developing states against developed host states, and so that in a way reverts the sense, the most usual sense of the tension between capital exporting states and capital importing states, between developing and developed states in terms of who is to expect to be on the claimant or respondent side, or to instinctively espouse the position of claimant or respondents in investment disputes. There was a very short discussion. There was one voice was heard, in my recollection at least, for whether the equal representation should also be an equal representation of the different ages of a man and woman, one might add. But this one voice was, of course, from an arbitrator who's, by my calculation, over 85. So as popularity waned, saw that it was a perfectly good opportunity to try and get a second round at that same rodeo. But it's not, all puns aside, the issue of a sufficient and efficient representation of younger members of the legal community, and on par at least with older and even the oldest members of the legal community is one of the considerations to take into account. One point that was raised and has not been completely resolved as yet, and possibly we will hear some interesting discussions on this next week in Vienna, is to what extent actually the representation that takes place in the constitution of a tribunal is a representation of the parties or a representation of the lawyers who represent the parties. And by this, I mean there is the caseload of ICSID. I think the last publication mentions some 700 cases administered by ICSID, between ICSID proper and ICSID additional facility cases, though the lawyers that have made pleadings in those 700 cases are quite possibly less than 700 lawyers. And every case involves at least 10 lawyers per side. So as you can see, it's the parties, however diverse they are many times represented by repeat players from law firms. There's a few unfortunate states that have also been vested with the dubious honor of being a highly repeat player. And on a biographical note, I've had the privilege of working with probably the one who had the first iteration of this problem at some point in 2005, when I started working for Argentina in the defense of its investment cases. The ICSID had ongoing some 82 cases. 41 were against Argentina. So 1 in 2 cases basically had the same lawyers, and of course there was not a law firm. Argentina defended itself through its state attorney's office, but you had there a very small number of people appointing the 3-member tribunals for half of the ongoing caseload of the institution. This is just to add one last very interesting point that is not usually taken into account, is the issue of the language diversity. And this has some complications which are somewhat unsurmountable and listen until we manage to find a workaround to the language in the ICSID Convention. ICSID Convention, of course, we know has 3 official languages, being Spanish, English, and French. There is no way to force a tribunal to take or adjudicate a dispute under the ICSID Convention in other than English, French, and or Spanish. If any party chooses one of the official languages, then the proceedings shall occur in that official language, which means that as many as 3 official languages for an award can exist in ICSID parlance. I have worked in cases where all 3 languages were being used. There was luckily an agreement that only 2 of the languages will be used for drafting the award. But what that means is all this discussion on diversity at some point is funneled down whether each of those members of that tribunal speaks one of the 3 languages or all 3 languages, or is willing to execute an award which that person has not been able to actually read, draft, or decide on because it doesn't have the linguistic capabilities. And that is something that is not very usually perceived as a problem of the magnitude that it is. There's very few scholarly writings on the issue. There is one book by Thibaut Varady called Language and Interpretation in International Arbitration. I studied interpretation together with law when the last millennium had not ended yet, and so I, of course, took an interest in the issue. Probably I purchased 2 of the 7 copies of that book that were sold in the Americas. I actually made it a point to give one of the 2 copies I had purchased to Mick, Secretary General of ICSID, when we had the issue that the chair of a tribunal did not speak the one language on which the award had to be issued. And we actually got communications from ICSID that the delays in having the award circulated to the parties was that ICSID was translating it. But it was translating it from something that was not one of the languages of the proceeding, which puts the whole integrity and the actual choice of language and expressions in the award into question in terms of whether they can actually be attributed to the members of the tribunal. All of these considerations, which seem to be limited to the issue of the identity of who decides and the specific case which that person is allowed to decide, is not isolated from the other 3 main dining rooms in the little house in the prairie that Ange Van Brett was mentioning. The note from the Secretariat dealing with the issue of arbitrator appointments actually makes this a very useful remark with which I will close before Sergey turns my microphone off. And what the Secretariat says is that taking all of these issues into consideration, coming to satisfy the concerns of the international community regarding the several forms of diversity that have to be represented and the way in which the process to appoint a tribunal is crafted is, and I quote, is required in order for the reform options to usefully address the identified concerns and for ensuring the credibility, integrity, and legitimacy of any ISDS regime that would result from the reform process. As a general principle, the selection and appointment methods should be such that they contribute to the quality and fairness of the justice rendered, as well as to the appearance thereof. The working group may wish also to consider the issues that a reform of the selection and appointment mechanisms would seek to address include the following: repeat appointments, instances of conflict of interest and or so-called issue conflicts, and the practice of individuals switching roles as arbitrator, counsel, and experts in different ISDS proceedings. This is probably one of the most challenging issues faced by the ISDS system right now. Without a proper and full solution of the many issues surrounding the appointment of arbitrators, every other aspect that is being discussed simply makes no sense to really invest any time in. If we don't have trustworthy tribunals that are bound to act within the limits of the deontological duties to the parties and the arbitration centers. Any other conclusion on how the treaties should be drafted or should be interpreted is not really of much effect, because we will not get to see that decision actually implemented in the awards that we end up receiving. And with that, and apologizing for the additional time, I thank you very much.
Thank you, Diego. I think you identified quite a number of issues and concerns to be dealt with. I now give the floor to Evgenia to tell us how it is possible to organize a court that will address all of these various concerns that Diego and others have identified and would work smoothly and perfectly. Thank you, Evgenia. And you mentioned one issue of addressing issues in reverse order. I think we as lawyers sometimes address issues in a reverse order to how the clients would see them, because before you discuss this wonderful, wonderful court that we can create to address all of the issues, one of the questions that will be asked first is, are the decisions of that court going to be enforced anywhere? And to answer that question, I give the floor to Mikhail.
Good evening. First, allow me to warmly thank the International and Comparative Law Research Center for the honor and privilege of inviting me to Moscow to share my thoughts on the investment court system reform with exceptionally qualified colleagues and a distinguished audience. And naturally, I would also like to thank Sergei for moderating this discussion. As the previous speakers have in-depth and extensively addressed different aspects of the investment court system reform, I will try and keep my presentation as short as possible to save time for our discussion, which I'm sure it will be fruitful and to which I look forward to. So, as you probably know, the title of my presentation is Enforcement of the Decisions of Permanent Investment Courts. An alternative, less descriptive, and certainly more controversial title could be The Road to Hell is Paved with Good Intentions, a saying that, as I understand, exists also in the Russian language. This is not to say that the current system constitutes a paradise. On the contrary, as highlighted in the previous presentations, the status quo is far from perfect. Many, but not all, many of the criticism leveled against the system do not lack merit. Under the current system, domestic courts have a very limited role in relation to the review of awards rendered by investment treaty tribunals, which is a good thing. Nonetheless, we currently see domestic courts adopting an increasingly interventionist approach when reviewing such arbitral awards, even in jurisdictions which traditionally were considered arbitration-friendly. Singapore is one, but not the only example. The ICSID system provides no role for domestic courts at all. Awards can only be reviewed by ICSID ad hoc committees, not domestic courts, on a very limited set of grounds, namely 5, that the tribunal has manifestly exceeded its powers, that there was corruption, that there has been a serious departure from a fundamental rule of procedure, and that the award has failed to state the reasons on which it is based. However, and despite a plethora of annulment decisions, or perhaps because of it, the case law of ICSID ad hoc annulment committees is neither consistent nor easily predictable. Investors can also enforce awards against states in the majority of the countries of the world, including the most important jurisdictions in terms of enforcement possibilities and sophistication of the legal system. And this is using either the New York Convention or the ICSID Convention. Now, this undoubtedly constitutes one of the main advantages of international arbitration as opposed to transnational litigation. Regarding enforcement in particular, with very few exceptions, the most notable exception is the European Union, there is no global, comprehensive system for enforcing court judgments. which is comparable to either the New York Convention or to the ICSID Convention. However, despite its shortcomings, the system governing the enforcement of investment treaty awards functioned for many years in a more or less satisfactory manner. And indeed, although investment treaty arbitration has been and is currently being fiercely criticized from a plethora of perspectives, enforcement was not one of them. Now, what is surprising, and I would say unfortunate, is that while much emphasis has been placed on other features of the investment court system reform, it is clear that no much thought has been given to the issue of enforcement of their decisions, of the decisions of the investment court systems. And on that regard, there is significant uncertainty. And the term uncertainty, I'm afraid, is a euphemism, at least from certain perspectives. Because in case of a first instance arbitration, which is followed by a voluntary or compulsory appellate mechanism, decisions could be enforced using the New York Convention. It is more difficult to consider that decisions rendered by permanent investment courts would constitute arbitral awards falling within the scope of application of the New York Convention. This is a question that I will address later as well in more detail. However, it is certain that without treaty amendments, which are very difficult, one might even say impossible, first instance or appeal decisions rendered by permanent investment courts do not fall within the scope of application of the ICSID Convention. Let me first turn to the New York Convention. The European Union, in its submission to UNCITRAL Working Group III, takes the position, and I quote, that awards under a future standing mechanism could additionally be capable of enforcement under the New York Convention. And the European Union argues that enforcement is possible for awards by permanent arbitral bodies according to Article 1, Paragraph 2 of the New York Convention. Now, allow me to read you the text of Article 1, Paragraph 2 of the New York Convention. And I quote, "The term arbitral awards shall include not only awards made by arbitrators appointed for each case, but also those made by permanent arbitral bodies to which the parties have submitted." And again, according to the European Union, and I quote, "There is no reason to consider that awards of a standing mechanism could not be regarded as such of permanent arbitral body, and hence enforceable, provided, of course, that the disputing parties have given their consent, which, by definition, they would have done." Now, Professor Kaufmann-Koller and Dr. Protestat in their report have examined the travaux préparatoires of the New York Convention and conclude that at the time of drafting the New York Convention, no one envisaged a permanent investment court. Professor Kaufmann-Koller and Dr. Protestat conclude that indeed, decisions rendered by permanent investment court could fall within Article 1, Paragraph 2, either on the basis of an evolutionary interpretation or using the ordinary meaning. These are the criteria under the law of the treaties. Nonetheless, in my opinion, it is not obvious that decisions rendered by the investment court system could constitute arbitral awards within the meaning of New York Convention. Now, it is true that awards of the Iran-US Claims Tribunal, which is a permanent international judicial body, have been regarded by US courts as falling within the meaning of Article 1, Paragraph 2 of the New York Convention. Nonetheless, it is not a given that all courts, all domestic courts in the future will adopt the same approach. Because in the case of the Iran-US Claims Tribunal, as well as the proposed investment court system, there is no agreement in writing between the parties to the dispute, nor there is a right to choose arbitrators. Now, in certain permanent arbitral institutions, which the drafters of the New York Convention had in mind, the latter is missing, but the former exists. And obviously, in traditional investment treaty arbitration, there is no agreement in writing between the parties to the dispute, the foreign investor and the host state, but undoubtedly both parties can appoint and do appoint arbitrators. It is thus not surprising that even according to the submission of the European Union, and I quote, "The instrument creating and standing mechanism should create its own enforcement regime, which would not provide for review at domestic level." But creating such a regime undoubtedly will take a long time, and perhaps will take an even longer time to reach the broad acceptance, perhaps one could say quasi-universal acceptance, that the New York Convention and the ICSID Convention currently enjoy. Now, as far as the ICSID Convention is concerned, I think it is clear that the awards, the decisions rendered by the investment court system cannot be enforced using the ICSID Convention. And this is a view shared by others as well. Because the ICSID Convention contains detailed rules about the composition of the panel of arbitrators, and importantly, Article 53, Paragraph 1 of the ICSID Convention, and this is something that we heard before as well, clearly provides, and I quote, that the award shall be binding on the parties and shall not be subject to any appeal or to any other remedy except those provided, of course, under the ICSID Convention. In particular, regarding the investment court system, which is established by international treaties concluded by the European Union, there is another complication, because the European Union is not, and according to Article 67 of the ICSID Convention, cannot become a party to the ICSID Convention. And even if the European Union and some other states, for example, I can think of Canada and Vietnam because they have agreements with the European Union in that regard, are allowed under the law of the treaties to amend the ICSID Convention inter se among themselves, and this is a big if, as Professor Ioannis explains, such an inter se modification would not affect other ICSID contracting states. And obviously, the disadvantage would be that the award in these third states would not be enforceable using the ICSID Convention. To conclude, this uncertainty regarding the possibility of enforcement, or even worse, in some cases, the certainty about the impossibility of enforcement, is highly problematic from a number of theoretical and practical perspectives. First, it is problematic from the perspective of the international protection that foreign investors enjoy or should enjoy. This protection is greatly diminished. It is also problematic, and this is closely connected to the first point, from the perspective of the global rule of law. It is also problematic for the operation of third-party funders. Now, an increasing number of arbitrations are funded today by third-party funders. Uncertainty regarding enforcement will significantly complicate or even render impossible the ability of investors to obtain such third-party funding. However, and this is the most important consideration in my opinion, creating a permanent investment court system without seriously considering whether, how, and to what extent each decision could be enforced undermines an imperfect but functioning system which took dozens of years to emerge organically without putting in its place a credible alternative. And I will turn to Baizu's fundamental question, I think, why it is important to protect foreign investors, which is the question is of fundamental importance. And I would say that this system of investment protection is not only a system of enhanced protection of private property and foreign investment. It is primarily, and I would like to emphasize that, it is primarily a system of peaceful resolution of international disputes on the basis of international law. And historically, the alternative to resolving peacefully international disputes by recourse to international tribunals was antagonism, diplomatic and economic coercion, gunboat diplomacy, and even war. One of the leading arbitral institutions on which Evgenia has presented is the Permanent Court of Arbitration, which, together with the International Court of Justice, share a beautiful neo-Renaissance building at The Hague, which is called the Peace Palace. Let us all, and in particular policymakers, bear this in mind when discussing and more importantly, when implementing reforms about the investor-state system. With that, I would like to conclude and thank you for your kind attention. And of course, I look forward to hearing your questions and ideas. Thank you very much.
Thank you very much, Mikhail. I think in light of the timing, I suggest before the approach that I understand the working group uses quite frequently, which is to break for a coffee break so that we may have some informal discussions and then come back for a formal discussion to continue, unless someone has a very pressing question that you must ask before that. In which case we would resume at 8 p.m. and I understand there is a coffee break and some snacks over there. Thank you very much once again.